Welcome to the second chapter and the 20th lecture of this lecture series on international arbitration practice. In the last lecture, we dealt with the preliminary aspects of notice of arbitration and reply to the notice of arbitration. We also provided a checklist of items to be ensured before issuing the notice of arbitration, which you can access from the comments column to this video. 3 preliminary comments before we go to the lecture. 1. Just prior to the last lecture, there was feedback from the audience that the audio was feeble. We promised in the last lecture to take steps to resolve the issue. Now we have attempted to resolve it from this lecture. Please let us know if the audio is proper in this lecture. A comment to this video providing feedback would be great. 2. Feedback is extraordinarily important, especially for lectures on YouTube, where communication is virtually one-sided. I am really thankful to those viewers who send comments or who mail me regarding the lectures. It would be really great if you could can please post your comments giving feedback, whether it may be good, bad or ugly. The third aspect is this lecture is quite long, with lengthy quotes from a contract. To avoid boring you and to make it simpler, we have provided the relevant contract clauses in the video, but we would not be reading those clauses to you in greater detail. Instead, we will summarize what these clauses say. So, our request is for you to pause the video whenever a clause is quoted and read it for yourself. Now, let us begin. In this chapter, we will provide 2 factual situations, one from investment treaty law and another from commercial arbitration, mainly international commercial arbitration, through which we will demonstrate various aspects regarding invocation of arbitration and reply to such invocation. The investment treaty law example that we will take will be based on the case of Chevron Corporation and Texaco Petroleum Corporation versus Ecuador. It's a PCA case numbered 2009-23. We have selected this case because the pleadings are available in the public domain. We have provided the link to access the pleadings in the comment to this video under the heading References. But unfortunately, commercial arbitration is confidential in nature. So, we will be dealing with a hypothetical case or 2 and will develop the details of the cases as we go through each lecture in this chapter. In this lecture, we would not be dealing with the investment treaty law example. Maybe in the coming lectures, we will deal with that. But in this lecture, we will take the case of a notice of arbitration in a commercial dispute. And we will be taking a simple contract for design of customized software for the purpose of design automation of engineering components. So this is basically a design automation contract. We will explain what design automation is in a moment. Now, before that, let us just assume that there is an owner, let us call the owner the client, invited bids from select parties for designing a customized software, and that customized software is for design of certain engineering components in respect of a particular industry. Let us assume that industry to be the power plant industry. So the work is for building a customized software for enabling the design of engineering components for a power plant. Now, the contract, as we said earlier, is a design automation contract. In design automation, the engineering knowledge is extracted and is used for effecting a rule-based design. For example, if the power that is to be generated is so and so megawatt, then accordingly, what are the kinds of components that are to be selected? Like for example, turbine or electrostatic precipitator, etc. So in such case, depending on the design and depending on the purpose and the output, what is the design of the power plant is what a typical design automation contract design automation software would help the engineers do. According to Autodesk, no matter the size of your company or whether you are fabricating and manufacturing many different types of products or just a few, there are likely repeatable patterns and workflows in every environment that can benefit from automation. So this is the purpose of this particular contract. See, we as lawyers need not get into great depth as to the nitty-gritties of the work that are involved, but it makes sense to have an understanding about what the contract is all about. Now, in this case, a software company in Singapore, along with its 100% wholly owned subsidiary, which is incorporated in India, was successful in the bidding process, which was initiated by the owner or the client. And so the client issued the letter of intent. Just a week prior to signing the contract, the Singapore company felt that it would be administratively convenient for its Indian subsidiary to enter into the agreement and coordinate with it for performing the services. So what the Indian subsidiary did is, the Indian subsidiary of the Singaporean company, that is the contractor, signed the contract with the client. Let's take that the agreement was signed on say 31st December 2021 or any day in December 2021. Now, just to briefly touch upon various provisions in the contract and the scope of work along with the milestones for payment, what we have done is, instead of just reading through this, we have provided a crux of it in this slide. So this is the milestone. There are various stages or milestones under the contract. So the scope of work is divided into several milestones. In this case, there are about 7 milestones. So this slide gives you 3 milestones. The next slide gives you the remaining 4 milestones. So there are 7 milestones, and as soon as one milestone is completed, the corresponding percentage of contract value of amount is to be paid by the client to the contractor. And the second column is the description column, which provides for the deliverables which are to be given to the client by the contractor for successful completion of a particular milestone or stage. So my request is, pause this video and have a detailed look at the contractual milestones. So the total consideration was rupees 10 crores, and those who are not familiar with the Indian numeral system, rupees 10 crores is rupees 100 million. Okay, the duration of the contract was 14 months, and the duration of the contract was to commence from 1/1/2022. So 14 months means the contract was supposed to end by the February 2023. The clause on governing law, arbitration and jurisdiction in the contract provided. You may pause your video to read the clause. This is Article 21. Article 21A talks about governing law, 21B talks about arbitration, and 21C talks about the jurisdiction. Hope you have read the clause. It will be quite difficult to remember these facts in this lecture and in the following lectures. So a fact sheet has been uploaded and its link provided in the comments to this video. Do download it and have a look at it. Understanding the facts is important for you to follow these lectures. Basically, these lectures are from a practice point of view, and that is why understanding the facts is the key to understanding the lectures and what is being spoken about. Now, coming back, the problem in this contract is this. So, as on 30 April 22, that is within 4 months of the completion of the contract, the contractor completed 2 milestones out of the 7, and the client on 5/5/2022 paid rupees 2.5 crores or in the American system 25 million to the contractor, which is equal to 25%, that is 10% plus 15% of the milestone payment. If you just go back in this video, you will notice that on completion of the first 2 milestones, the contractor is supposed to have completed 25% of the work and correspondingly would receive 25% of the payment. 25% of 10 crore is 2.5 crore or 25 million, which was paid to the contractor by the client on 5/5/2022. Now, coming to the problem, another client of the contractor who was supposed to pay the contractor did not do so, owing to the client, not the present client, the client of the contractor in another contract. The client was referred to insolvency, and the contractor was unable to receive any amount from that client and was also unable to pay salary to its team who were deployed on the job under the current contract under discussion. The contractor also did not have any alternative team to be deployed for this job with the present client. So the contractor also had to complete this project on time, and if he fails, then that would mean that the client would fail to meet the deadlines that were committed to its top management, resulting in considerably lesser score being awarded to that branch office of the client and a lessening of the performance related pay to all the employees in the client's branch. So this is the problem for the client. So you are an in-house counsel, assume, with the client, and the technical department who's handling this contract approaches you on say 10/5/2022 seeking a legal solution to the issue. You advise them to rely on the termination clause, which is going to be quoted here, and you advise accordingly. Please pause the video and read the termination clause in full. The termination clause has considerable importance for the present purposes, so kindly read it in full. Just to summarize, the first subclause of this termination clause provides for termination on account of default of the contractor. It says that it enables the client to terminate the contract after a reasonable notice to the contractor, right? And the other aspect is the contract in whole or the part of the contract can be terminated as per this clause. And the grounds under the first subclause are failure by the contractor to comply with the terms of the contract or making poor progress in the execution of the project. So in these grounds, the client could terminate the contract. In addition to the grounds provided, subclause 2 says that if the contractor assigns, transfers, subcontracts, etc., this contract or any portion of it without prior written approval of the client, or if the contractor failed to deploy competent manpower or equipment, as it happened in this case, or if the contractor failed to comply with the requirements of applicable laws, or if the contractor or any employee, laborer of the contractor was involved in corrupt practices, then the contract could be terminated. In addition to the termination, the contractor could also be banned for a future period of 3 years, or as the client may decide in case of termination for corruption. Now the third subclause provided that where the client exercises its authority to terminate the contract in whole or in part, the client could complete the work at the contractor's risk and cost. In addition to the charges that would be incurred for the risk and cost contracting, the client would also be entitled to superintendence and establishment charges. Then the fourth subclause provided that the right of the client to terminate the contract would be without prejudice to any other right or remedy. So this is basically the structure of this termination clause. So coming back to the facts, so when the client, internal client, that is the technical department which is managing the contract, comes to you, an in-house counsel, you advise the person to rely on the termination clause and issue a notice conveying the contractual breaches to the contractor. So acting on your advice, the concerned department issues a letter to the contractor conveying various breaches of contract. So that letter is also issued on the same day. Assume that you are efficient and you have advised it, and the other department has taken your advice seriously, and on that day itself has issued a letter to the contractor. And in the letter, the technical department has conveyed the various breaches of contract and has unequivocally stated that if the work is not resumed and the next milestone is not performed within the next 2 weeks, the contract would be terminated and the client would complete the work, that is the balance portion of the work, at the contractor's risk and cost. The letter also stated that the importance of the project and communicated that to the contractor. So this letter was sent on 10/5/2022 by email, fax and registered post to the designated address in the contract. The designated address of the contractor, that is. So despite the expiry of 2 weeks, which was the time given for the contractor to revert, that is on 24/5/2022. So 2 weeks from 10/5 is 24/5, 14 days. No reply came from the contractor, which was unfortunate. So on 25/5/22, the client terminated the contract. Okay, and informed that the client would inform whom? The contractor. That the client would get the work completed at the contractor's risk and cost. The client also invoked the bank guarantee provided as a part of the first milestone. I'd request you to go back to the milestones that was there in this video. Pause them and read the first milestone. You would notice that the first milestone provides for security deposit through bank guarantee to the extent of 10% of the contract value. So the contract value is 10 crores or 100 million. So 10% of 10 crores is 1 crore or 10 million. So we also saw that the contractor had performed the first milestone, which included furnishing of this guarantee. So on the facts, the client invoked this bank guarantee, that is for 10 million or 1 crore, and got it in cash from the bank. So accordingly, on 25/5, the client floated another tender for completing the balance 5 milestones. 2 milestones out of the 7 had already been completed, so the balance was 5. For this purpose, the client floated another tender. Within 5 days, bids were received, that is on 30/5/22, and on the same day, the client assessed the lowest bid, which was 10 crores, that is 100 million, for completing 5 milestones, remember, not 7. So on 31/5/22, the client awarded the contract to the lowest bidder, that is the one who quoted 10 crores, and the contract was supposed to be completed in 10 months, that is by 31st March 2023. Let us call the lowest bidder as contractor 2. So after awarding the second contract to contractor 2, your technical department once again contacts you for advice, and you tell them that the difference in price needs to be claimed from the first contractor, and you ask the technical department to send a letter to the first contractor stating that the risk and cost contract has been awarded, and that on completion of the risk and cost contract, the difference in price for completing the balance portion of the contract would be recovered from the first contract on the completion. Accordingly, the technical department sends a letter on 1/6/2022 to the first contractor. Now, our endeavor would be to use this factual scenario and also the checklist that we had prepared in the last lecture. If you recollect, in the last lecture, we had given a checklist. The checklist was for the things that needs to be verified or examined prior to issuing a notice of arbitration. So likewise, in this factual scenario which we discussed just now, we will have a look at each item of the checklist and explore how the client should proceed. So please recollect that in the last lecture we had used a checklist. We'll use the same checklist and determine what are the things to be done or to be determined or ascertained prior to invoking the arbitration. Serial number 1 of the checklist is claims, nature of claims, and the amounts claimed. Claim would be the difference between the contract price for the risk and cost contract and that of the original contract, but for the unfinished portion thereof, in addition to superintendence and establishment charges. You can call the superintendence and establishment or administrative charges. So serial number 1 is contract price for executing the unfinished work at the risk and cost of the contractor, that is the contract number 2. The contract price is 10 crore rupees or 100 million rupees. Superintendence and establishment charges is pegged at 5% of the contract price based on standard industry practice, which is 50 lakhs or 5 million rupees. Then the cost of executing the balance work under the contract is 7.5 crores or 75 million. Note that the original contract price was 10 crores, 25% of the work was performed and therefore 2.5 crores was released. The balance 7.5 crores worth work was remaining. And you would also notice from the fact sheet that the security deposit in terms of the bank guarantee was appropriated, and therefore we add serial numbers 1 and 2 here and reduce it by serial numbers 3 and 4. So the total claim that works out is rupees 2 crore or 20 million rupees. This is in addition to any interest that is to be charged. The claim is, it may be noted, planned to be filed against both the Indian and Singaporean companies, applying the group of companies doctrine and for better chances of enforceability of an award, if any, that comes in favor. Serial number 2 of the checklist is evidence of the claims such as documents, persons involved at the time of the transaction, performance and breach. The documents to be submitted would include the notice inviting tender, the contractor's bid, the letter of intent, the letter from the Singaporean company that the agreement would be signed by the Indian subsidiary as contractor, the agreement itself, any minutes of meetings between the client and the contractor, evidence of payment of 10% and 15% milestone payments, communications between the client and the contractor regarding the breaches, then notices by the client, termination letter, NIT of the risk and cost contract, evaluation of bids received of the risk and cost contract and the risk and cost contract itself, then notice regarding award of risk and cost contract to the original contractor, calculations, evidence of cost towards superintendence and establishment charges, may be supported by salary slips of employees who have been deployed for the work on risk and cost contracting. So see, these will be the evidence that would be filed. Serial number 3 of the checklist is existence of arbitration agreement and possible grounds of challenge of the arbitration agreement. Arbitration clause here is a part of the main agreement. So there are less likely chances that the arbitration agreement's existence would be challenged, except maybe in relation to appointment of own employee as arbitrator. My request is kindly go to the arbitration clause that is provided in this video, or you can have a look at the fact sheet whose link is provided in the comment section to this video. You will notice that the arbitration clause provides for appointment of the client's own employee as arbitrator. It is unlikely that the client's own employee would be accepted as arbitrator by the opposite party. It is also hit by the Arbitration and Conciliation Act as amended in 2015. So the notice invoking arbitration should ideally provide for a neutral arbitrator. Chances that the opposite party may not agree with the same are there. So there is also a chance that the court might have to be approached for appointment of arbitrator under section 11 of the Arbitration and Conciliation Act. Serial number 4 of the checklist is the applicable laws. That is applicable laws of the arbitration agreement, jurisdiction and law governing contract, etc. So the law governing contract, including the arbitration agreement, would be Indian law in view of the governing law clause. The venue is New Delhi. And since there is no other contradictory indication in the agreement, the seat would also be New Delhi. Serial number 5, availability of alternative remedies such as through tribunals, courts or arbitration and appropriate remedy. Since there is an arbitration clause, there is no requirement for alternative remedies. Whether the claims are within the limitation period? Yes. The claims are within the limitation period if filed immediately in 2023 as per the fact sheet. The legal strategy to be adopted in legal proceedings is the next item in the checklist. I think you may have a look at the comments to serial number 1 of the checklist. In addition, oral and documentary evidence are to be led. Serial number 8, necessity of pre-arbitration provisional relief or emergency relief. For this, the bank guarantee has already been invoked by the client, so there is no need for such a relief at present. Serial number 9 is whether there are pre-arbitral dispute resolution processes involved and whether the requirements as provided in the agreement have been complied with. We are safe here because there is no such requirement in the agreement. The next item in the checklist is whether it is fruitful to attempt amicable settlement of the dispute. Since the contractor has not responded to any of the notices, the next way forward is to invoke arbitration, but the possibility of settlement need not be ruled out. The notice invoking arbitration may provide that the client would not be averse to going for conciliation and conditions associated therewith may be mentioned there. Estimate of legal cost to be incurred, say, assuming that a mid-experienced counsel rather than a senior counsel, designated senior counsel is to be appointed. So instead of going for such designated counsels, if a mid-experienced counsel is chosen, then assuming rupees 1 lakh per hearing, so and assuming 20 hearings, so the cost would be close to about 20 lakhs. Then the arbitrator's fees would also be included there, and administrative expenses of 5 lakh rupees. So these would be the estimates of the arbitrations fees, etc. Then cost towards pursuing the petition under section 11 for appointment of arbitrators, if there is one, would be 25 lakhs because it is an international arbitration, so the Supreme Court has to be approached for section 11 proceedings, and engaging advocates in the Supreme Court are likely to be more costly. Then there are other costs involved such as travel, administrative expenses, etc., which would run to about 10 lakhs. So in total, the estimate could be around 60 lakh rupees. Then the 12th item in the checklist is counsels, senior counsels, experts to be appointed. We had already stated that there was no need for a senior counsel, but a mid-level counsel may be appointed. The fee likely to be charged by a mid-level counsel could be around 1 lakh rupees per hearing. And there is no need for expert evidence because the issue does not involve complicated technical matters. Then the last item in the checklist is the arbitrator who sought to be appointed independent, impartial and available. So let's assume that the in-house counsel of the client contacted a retired general counsel of a reputed Fortune 500 software company in India to act as arbitrator, and he has also agreed to the same and has declared his independence, impartiality and availability. So by the time you collect all this information and prepare and complete the above checklist, the work is complete. That is work under the risk and cost contract, which is complete by 31 March 2023. Now the technical department comes over and hands over all the files and papers to you for recovering rupees 2 crore, that is 20 million rupees, which is the loss suffered by the client under the contract. So on 5/4/2023, you issue a demand letter to the contractor and his Singaporean parent for payment or for notice to pay the said amount of 2 crores in addition to interest at 18% per annum within 2 weeks. But let's say that the original contractor does not pay. So you once again send reminders on 20 April and on 28 April, but there is no response. So now you have no other recourse except to initiate arbitration. We'll deal with invoking arbitration in the next lecture, and we'll continue to use the same example throughout the lecture series. Okay, so this is the method to deal with claims. A similar exercise is undertaken if you are an external counsel. In that, there is not much of a difference between the role of an internal and an external counsel as far as due diligence is concerned prior to invoking arbitration proceedings. So more on this in the next lecture. Bye bye and stay safe.